CBS Atlanta News presents Public Affairs on Peach.
Well, it's an issue that's getting reaction from pretty much everyone these days. A new mandate from the Obama administration that insurance companies must cover contraception for women free of charge. Good Sunday morning to everyone. I'm Brandon Rudat. The move by the Obama administration has really angered a lot of religious conservatives who say the mandate here violates the First Amendment. Already 7 states had sued the federal government over this mandate. The federal rule now requires all health insurance providers to cover contraception and birth control services. Nebraska, Michigan, Ohio, Oklahoma, South Carolina, Florida, and Texas all filing lawsuits. They say the mandate is a violation of the First Amendment and the Religious Freedom Restoration Act. All right, the question is here, does the mandate here violate the First Amendment? Kathleen Bursch teaches constitutional law at Atlanta's John Marshall Law School. She joins us this morning. Professor, good morning to you.
Good morning.
It's good to have you here because a lot of times when we're talking about the constitutionality of laws, things can get complicated here. There was a big fight by religious conservatives for when the president first came forward with this. And they said, you cannot force us as a religion, if we do not believe in contraceptives, right, and giving this out to women, right, you cannot force that upon us. Is that true?
It depends. It depends on how the government is regulating the requirement to provide contraceptives. If the government were requiring the religious organizations to provide the contraceptives directly, then likely that would violate the Constitution. However, if the government is regulating the activity as a general, what's called a general rule of applicability, and the religious organizations are caught in that general rule, then the issue becomes a little trickier. The court has really tried to decide these cases based on whether or not there is the general rule and then whether or not the program can actually be handled or the government's interest can be accomplished with these exemptions.
Because when you have the Catholic Church coming forward saying, hey, listen, we don't believe really in birth control, okay? So we should not be responsible to provide out of our pocket for members of our own religion, even if they're employees of ours, to basically pay for their contraceptive pills.
What's happening is it's not just, the Catholic Church is not just hiring Catholics. They're hiring non-Catholics as well in the organizations that are going to be captured by the president's or the administration's rule. So this rule is capturing things like schools, hospitals, Catholic charities. So it's capturing those organizations where the church is acting outside of the church. It's acting in social services areas, places that private businesses act. And the court has said when you step outside the church and act like a private individual, we have a lot more leeway, and the government has a lot more leeway in regulating your behavior.
So when this goes to the courts, and certain judges are seeing this, but we're talking just briefly about how the Health Care Act in and of itself, the legality of it, is it even constitutional? Is it even constitutional to force people to carry insurance in order to people to have insurance in general? What say you to that?
Well, the mandate itself to carry insurance, my guess is this court could go either way, the Supreme Court. It's had decisions that have split 5-4. My guess is it's going to be a 5-4 decision either way. Justice Kennedy will probably be your swing vote. But my guess is the court's going to come out and say that this is adequate or a usual exercise of Congress's Commerce Clause powers. Because what we're doing here is regulating insurance. Insurance is really a business. It crosses state lines, and Congress can regulate this way. It's really no different in some ways than about a century ago when we started to say, look, employers and employees, you have to pay a Social Security tax. And so the way I would think that the court may look at this issue is much like it did the Social Security Act back in the early 1900s and said, look, we're regulating private behavior, but we're doing it for the common good. We're doing this because it's economic, and we need to regulate everyone in order to capture and make sure the program's successful. And to kind of link that question back to the healthcare mandate, the Amish actually challenged the Social Security Act on religious grounds. And the court said, sorry, you lose because this is a law of general applicability. And in order to allow these exemptions would then have the system fail. So the court's really concerned about the exemptions when they would start to allow an individual to sort of piecemeal decide when they're going to obey the law or not. And then if you start to allow different organizations to have
opt out of it,
to opt out, then how do you actually make sure that we have some sort of solution to our problem?
When we were watching on TV recently at some congressional hearings on women's rights, on contraceptives, and it was all men testifying before Congress, does the Supreme Court, okay, when they go to ever take up this issue and they take over, do they look at what's being said in those congressional hearings to ever help make a decision? Because what I'm trying to understand is those hearings that we saw, while many say were not a woman's view by any means, because mostly they were all men testifying, does that ever sway the Supreme Court?
Maybe. So the cynical answer is only when the court wants it to. So basically, the court will take.
I guess I'm asking: is that seen kind of as evidence showing, support for a certain way?
If the law is ambiguous, meaning from the face of the statute, the court cannot, whether it's the Supreme Court or a lower court, cannot determine how that law is supposed to apply to a particular situation. The court will then look at legislative history.
Okay.
And how persuasive the legislative history is, we see the court going back and forth, kind of depending on whether it supports the decision it wants its outcome. So when we had the Violence Against Women Act, lots and lots of testimony in Congress to support the act. The Congress said, we don't care, doesn't matter. Then we take a look at the partial birth abortion statute, and the court said, look, there's a lot of testimony in Congress. We're going to rely on and give deference to Congress in this area. So it depends.
This is what I don't understand, and I think we were talking about this earlier, saying that I had health insurance. Were there health insurance companies that were saying no to women trying to get contraceptive pills? Is that why we ended up coming out with this mandate?
The mandate actually is not all that unusual. There's actually 28 states that already require employers to provide access to contraceptives for employees.
Because I'm just curious, and maybe this is me being cynical of an election year and a political cycle here, is why is this issue even coming up?
The issue is coming up because over the decades, as more and more employees became covered by health insurance by their employers, the cost for women for health care is much higher than it is for men. There was actually a study done by an independent agency that the Obama administration relied on when it came out with this ruling, the need to cover women's health care in this. And what we find is it provides for the actual health care that women are being provided access to, contraceptives and others, are preventative medicine. So it means healthier babies, it means healthier families, it means less types of cancer for women going forward. And so we have a healthier workforce, more productive workforce. So my understanding from the information in the public realm is that we're at this point because we're trying to equalize the access to health care for both men and women. And the states that have the provision in place have done so because they believe it's an equal protection question, which actually, if I could kind of link back to something we haven't talked about yet, is how this case is different than other cases. And all of the free exercise cases, which is really where the Catholic Church and the other churches are focusing, where they're saying, you can't have me provide this kind of care because it violates my religious beliefs. In all the cases in the past where the court's taken a look at the free exercise rights, it's never had a balance the church's right against an individual's right. And this case is going to be different because what we'll see is the court trying to balance the church's right against individual women's right to have equal access under the law to health care.
All right, thank you very much. Kathleen Birch, we appreciate your time with us this morning talking about the Constitution. Not an easy thing sometimes.
Not an easy thing.
Not an easy thing. Thank you for your time. Coming up, it is a picture that has many people scratching their heads. Take a look at the religious leaders who spoke to Congress about the contraceptive mandate. The image here has some wondering, where are the women?